I welcome you to the class on Indian polity. A few of the candidates wanted to know the present position of Article 31 because it will be useful for mains examination. What is the present position of Article 31? That is the question they asked me. Now let us see the first position of Article 31. You know, Article 31 was dealing with right to property. This fundamental right was deleted through 44th Amendment Act 1978. It was for the first time that a fundamental right was deleted in the constitutional history of India in 1978 by Janata government. Along with Article 31, one more freedom, that is Article 19(1)(f), which gave the freedom to acquire, hold and dispose of property, was also deleted. Remember, both these were in Part 3, that is the fundamental rights, which have been protected by Article 13 and also Article 32. Article 13 says that state shall not make any law which takes away or abridges any of the rights conferred in Part 3 of the Constitution. If any law is made taking away or abridging any of the rights conferred in Part 3 of the Constitution, that law to the extent of inconsistency is null and void. For enforcing this judicial scrutiny, Article 32 is there. Article 32 itself is a fundamental right. And Supreme Court is the custodian of the fundamental rights. So it cannot refuse to entertain. Now, even though these two fundamental rights were deleted through 44th Amendment Act 1978, they have been placed under Article 300A in Part 12 of the Constitution. Part 12 of the Constitution. So 44th Constitutional Amendment Act 1978 added a new chapter, that is chapter 4, under the caption Right to Property. What is the caption of the new chapter? Chapter number is 4 and the caption is Right to Property in Part 12, very important from PT point of view. And this chapter has got only one article, that is Article 300A. Right to property has now been placed in the constitutional right instead of fundamental right. Fundamental right Part 3, it has been taken away from Part 3 and put in the special chapter 4 of Part 12 as a constitutional right under Article 300A. What Article 300A says? No person shall be deprived of his property except by a procedure established by law. So there should be a law. That law should be passed by the valid legislature and that law should provide a procedure, and after following that procedure, the property can be deprived of. The same, what was earlier in Article 31, the same wordings are there in Article 300A also. But now this is a constitutional right. Previously it was fundamental right. That is the difference. Now what is the implication of converting a fundamental right into a constitutional right? First thing is, right to property can be regulated, can be curtailed, can be abridged by using a procedure made through an ordinary law of Parliament. So what is the? No person shall be deprived of his property except by a procedure established by law. So if an ordinary law is made to regulate the procedure of depriving a person of his property, that is valid. That is the first implication. Second is, it protects the private property only against the executive action, not against the legislative action. Executive cannot take any action, but legislature can take action by making a law. So this is the second implication. Thirdly, in the case of violation of this right, Article 300A, you cannot go to the Supreme Court under Article 32 because 32 is resorted to only where there is a violation of fundamental right. This is no longer a fundamental right, so you cannot go to the Supreme Court under Article 32. Instead, where you can go? You can go to the High Court under Article 226, which is only the discretion of the High Court. Remember, it is only the discretion of the High Court. Fourthly, there is no guaranteed right of compensation in the case of acquisition of property by the state. There is no guarantee, because the procedure, what is the procedure laid down? It may be bad in law, maybe good in law. That is not the question here. There is no guaranteed right of compensation in the case of acquisition of property by the state. Remember, when the deletion of Article 31 through 44th Amendment Act was taken, when it was challenged in the Supreme Court upheld the deletion of Article 31 through 44th Amendment Act. Now, when we talk of the right to property as a constitutional right, you should remember the classic case in which Supreme Court has recently given a decision. In January 2020, the Supreme Court had the two judges bench, I think Justice Indu Malhotra and Justice Ajay Rastogi. Two judges have given a wonderful decision. I mean, ever remember it, deserve to be remembered forever. The case relates to acquisition of private property, that is land, by the state. Article 300A, which is presently a constitutional right, says that no person shall be deprived of his property except by a procedure established by law, as I already told you. The case is very simple. There is a lady called Vidya Devi. What is the name of the lady? Vidya Devi. She is a widow in Hamipur district of Himachal Pradesh. 52 years ago, the Himachal Pradesh government forcibly took over the 4 acres land of Vidya Devi in Hamipur district for construction of road. When it happened? 1967. The state government took over the land forcibly on the pretext of adverse possession, without following the procedure, without any authority of law. Remember, there is no procedure, there is no law. The state government took over the land on the pretext of adverse possession. Now you should know what is adverse possession. What is adverse possession? Adverse possession is applied when the original owner of the immovable property leaves the property unattended for a specified period of time. If the original owner of the land leaves his land remaining unattended for a specified period, that is called adverse possession. What is that specified period? Law of Limitation 1963 says this is 12 years. So the specified period under the Limitation Act is 12 years. The assumption in such cases is that the original owner of the property was not aware of the right over his immovable property. So the appellant, what is her name? Miss Devi, is an illiterate person. She is a widow, coming from a rural background, wholly unaware of the rights and entitlements in law. So she did not take any proceedings, file any proceedings for the compensation for the acquisition of land forcibly by the state. Now, she first learnt about her right only in 2010 from her neighbors, who had also lost the land in the similar way. Now, when she was 70 years old, by then, that is 2010, she approached the Himachal High Court. Wonderfully, the Himachal High Court asked her to file a civil suit in the lower court, because High Court is meant for some other very detailed, so we will not entertain. You go to the civil court, lower court, and file a civil suit. This was the advice given by the High Court of Himachal Pradesh. Disappointed over the approach of the High Court, Miss Devi went to the Supreme Court. The Supreme Court bench, consisting of Justice Indu Malhotra and Justice Ajay Rastogi, passed a very beautiful with harsh words against the state. The Supreme Court said that in a welfare state like India, right to property is not only a constitutional right, not only a legal right, it is a human right. And grabbing the private land and then claiming it as its own makes the state as an encroacher. The state cannot trespass into the private property of a citizen and then claim the ownership of the land in the name of adverse possession. In the name of adverse possession. In addition to these strictures against the state, Supreme Court ordered a compensation of rupees 1 crore to Miss Devi, who is 80 years old today. So this was the position in the Himachal case, where Supreme Court has delivered a wonderful decision, wonderful judgment, proactive, affirmative, and simply courts cannot take shelter under the constitutional law, legal right or fundamental right, etc. In 1967, when this episode happened, it was a fundamental right. Even for the fundamental right, this is the position, means you can well imagine, if you convert this into a legal right or a constitutional right, what will happen to the poor citizens? So with this we will end the class. We will take 31A, 31B, 31C, which is in addition to 31. In replacement of 31, Article 31A added, 31B added, 31C added, and these are all exceptions to fundamental right. These three exceptions we will continue in the next class. Thank you.